Good evening and welcome to the launch of Volume 47, Issue 2 of the University of New South Wales Law Journal. On behalf of the journal, I would like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which we gather this evening. We pay our respects to elders past, present and emerging, and respect all Aboriginal and Torres Strait Islander peoples joining us this evening. My name is Sharanya Murthy and I am the Executive Editor of the University of New South Wales Law Journal for 2024. It is my privilege to commence tonight's official proceedings for the launch of Volume 47, Issue 2, a part thematic issue on the theme Developments in Rights, Freedoms and Accountability. Launches for the UNSW Law Journal are a reason to honour multiple matters. One reason is firstly to honour the incredible diversity of scholarly works the journal is publishing. From anti-corruption issues to suing enforcement bodies and international refugee cases, Issue 47.2 is a prime showcase of the journal confronting contemporary legal issues which impact lawmaking, academia and policy regarding human rights, government accountability and legislative reform. This celebration must also be extended to all the authors featured in Issue 47.2, some of whom we are thrilled to welcome here tonight, and we thank them for entrusting the journal with their academic works and for contributing to discourse on critical legal issues. In responding to such a comprehensive and contemporary issue, I would like to welcome and thank Mr. Perry Herzfeld, Senior Counsel at 11 Wentworth Chambers, who will be delivering tonight's keynote address on the journal's thematic topic. Secondly, launches are an opportunity to celebrate and honour the efforts of our brilliant and diligent student editorial body. It is truly remarkable that a group of 40 law students in Sydney, balancing their university studies, work and personal commitments, can come together to create such a diverse and intricate academic publication. From running to the library to pick up an obscure 19th century text to checking the italicisation of a comma, the board has done it all to ensure the successful publication of this issue. The hard work of the Executive Committee must also be recognised here, currently consisting of 5 issue editors, 1 forum editor and 1 digital editor. Running a journal truly takes a village, and without the countless hours of industriousness, wit and resilience of every editor here, this journal would not be the publication it is today. And of course, this launch is also to honour the editor of Issue 47.2, Brad Marzol. Brad is currently the journal's longest serving editorial board member, a fact he likes to remind us of every chance he gets. Joining the board as a fresh second-year law student and enthusiastically announcing to his criminal law class that joining the UNSW Law Journal was his fun fact over the summer, Brad has always displayed an extraordinary passion for legal research and editing. From being the journal's first submissions editor to now being the issue editor for 47.2, Brad's commitment to ensuring the journal's works are of the highest quality is unwavering. With knowledge of the Australian Guide to Legal Citation so in-depth it's a bit scary, wit and unswerving reliability as both an editor and a friend, the Executive Committee is sad to see Brad go. We're incredibly excited to see what you achieve next, Brad, and we know the journal is now in the very capable hands of your successor, Cordella O'Loughlin. My thanks also go to the UNSW Faculty of Law and Justice. In particular, our 2 wise faculty advisors, Professors Rosalind Dixon and Gary Edmond, and Professor Andrew Lynch, who is here tonight and has been the journal's most avid advocate. Lastly, launches are an opportunity to thank and recognise the extraordinarily generous contributions of the journal's premier sponsors. Corrs Chambers Westgarth is one of them, along with Allens, Herbert Smith Freehills and King & Wood Mallisons. Tonight's launch would not be possible without the continuous support of Corrs. My thanks goes especially to Cassandra Galea and Marianne Saliba for organising tonight. Corrs' invaluable sponsorship means the journal is able to maintain its status as one of Australia's leading academic law reviews, and for that we are ever so grateful. Thank you all for joining us tonight for Issue 47.2's launch. It is now my pleasure to welcome Andrew Corbell, partner at Corrs Chambers Westgarth, to speak on behalf of the firm.
Thank you, Sharanya. As Sharanya mentioned, I'm a partner of Corrs, and it's my pleasure to welcome you all here tonight on behalf of the partners of Corrs as a premier sponsor of the UNSW Law Journal and the host of the launch. The last time I introduced an issue launch for the journal, we hadn't quite moved into these offices, so particularly for those of you who haven't had the chance to get up here and share the view with us before, we're really delighted to have you up here. We take great pride in being able to share the opportunity that we've got in this space with as many people as possible. So I hope you enjoyed a drink beforehand, and please do stick around afterwards. I'm joined here tonight by my partner Michelle Gordon, who leads our clerk and graduate recruitment program, and also my newest partner Frida Chan, who's in the commercial litigation team with me and has just recently been promoted. If you haven't met them before the formalities, please do come and say hello to them afterwards. Corrs has a deep and proud relationship with UNSW. I'm pleased to say that both of the outstanding graduate lawyers that I'm currently supervising, Hayun Park and Varun Roy, are recent UNSW graduates. And Varun, as some of you will know or may remember, was also a member of the journal until last year. Looking back over the history of the journal, there is in fact a long and distinguished list of members and editors who subsequently worked as part of our team at Corrs in Sydney. I actually even had the privilege to share an office just this summer past with your own Guy Sutner. We'd like to congratulate all of the authors and editors who've been involved in the preparation of Volume 47, Issue 2. We recognise the enormous amount of work that has gone into the preparation of each of the diverse articles and the contribution that each of them and the journal more broadly makes to the legal community in Australia. Given the focus of the issue of the journal on the ever-important topics of rights, freedoms and accountability, as I watched the developments in the US this week in the lead up to the presidential election, I couldn't help but think that whatever the shortcomings might be in Australia on those topics, things could be a lot worse. On that note, I thank you again to the Law Journal for the opportunity to host the launch, and I'd now like to hand over to Brad, the editor of the issue.
Thanks, Andrew, for that warm welcome, and Sharanya for embarrassing me, but that's all right. Dating as far back as 65,000 years ago, the land which we call Australia has been inhabited by various Aboriginal and Torres Strait Islander tribes and clans. The arrival of the British First Fleet to Sydney Cove in 1788 saw Australia proclaimed as acquired by settlement. In 1889, the Privy Council affirmed this view in Cooper and Stewart, declaring that the colony of New South Wales was, quote, a tract of territory practically unoccupied, without settled inhabitants or settled law, at the time when it was peacefully annexed, end quote. The concept, but not the term, of terra nullius, meaning land belonging to no one, had evidently been deployed by the British to justify Australia's occupation. Countless decisions would rely upon these sentiments thereafter to deny Indigenous applicants recognition of their interest in the land. It would not be until the High Court of Australia's seminal decision in Mabo and Queensland No. 2, decided only 32 years ago, that the concept of terra nullius was discarded as a legal fiction. In delivering the lead judgment, the late Justice Brennan, as his honour then was, asserted that, quote, whatever justification advanced in the earlier days for refusing to recognise the rights and interests in land of Australia's Indigenous inhabitants, an unjust and discriminatory doctrine of that kind can no longer be accepted. The expectations of the international community accord in this respect with the contemporary values of the Australian people, end quote. In recognition of past and indeed ongoing injustices, and in the spirit of solidarity and respect, I wish to begin by acknowledging the traditional custodians of the unceded lands and waterways on which we gather tonight, the Gadigal people of the Eora Nation. I pay my respects to their elders past, present and emerging, and I extend that respect to any First Nations people that are here with us tonight. Welcome and thank you all for coming to another launch of another issue of the University of New South Wales Law Journal. I must say, as I stand up here tonight, It's a huge sigh of relief to see that journals of issue 2 are sitting in many of your laps and haven't gone missing this year. Tonight's event, like the journal's other launches, is a celebration. On the one hand, it is a celebration of the issue's 21 authors who have produced compelling and thought-provoking articles, and on the other hand, the hard work and dedication of each individual involved in its publication. However, in light of the issue's theme, developments in rights, freedoms, and accountability, it is also a time of reflection. One may say it's perhaps a time to reflect on whether the journal should still be described as a generalist law journal, considering its exponentially growing publication of articles on human rights, which I guess I'm guilty of facilitating in some respect, but we'll put that to a side. But more fundamentally, tonight is a time to reflect on how far Australia has come, yet how far it still has to go in advancing human rights, freedoms, and accountability. And I cannot think of better articles to encapsulate this sentiment than the ones that are published in this issue tonight. As I previously mentioned, issue 47.2 contains a thematic component titled Developments in Rights, Freedoms, and Accountability, of which 6 articles call home. Accompanying the thematic component are 4 articles which make up the issue's general counterpart. While the latter articles may not necessarily be housed within its thematic component, it would be remiss and naive of me, as the issue's proud father who loves all his 10 children equally, to suggest that they themselves do not aptly embody issue 47.2's theme. The first 2 articles of the general component are aspirational in nature, in the hopes of advancing rights, freedoms, and accountability for Australia's First Nations people. The first article, written by Harry Hobbs, surveys the status of Indigenous treaty-making processes within each Australian jurisdiction and the core issues stifling their progress. The second article, by Laura Griffin, examines the potential role of civil liability as an accountability mechanism against police officers and prison officials for Indigenous harms in custody that occur under their care. The pertinence of these 2 articles cannot be overstated. They expose that in light of the shortcomings in Australia's constitutional and criminal justice systems, we must turn to other means of promoting Indigenous sovereignty and redressing the injustices that our First Peoples face at the hands of those in power. However, and as both articles make clear, the implementation of such mechanisms cannot and should not be the end of the story. In the general component's 3rd article, Julia Tolmie, Rachel Smith, and Denise Wilson explored the New Zealand case Regina against Rudell to urge Australian jurisdictions to accept expert testimony from non-psychologists or psychiatrists on intimate partner violence entrapment to assist victim survivors in successfully raising self-defence in criminal proceedings. Finally, Lucy O'Brien, Ian Ramsey, and Paul Arley conduct an empirical investigation into the impact of the buy now, pay later industry on low-income consumers while endorsing the Commonwealth Government's move to impose stricter regulations within the industry to enhance consumer guarantees and freedoms. Now, this is quite topical at the moment given that the government's bill which seeks to impose these regulations is currently before the Senate. The first 2 articles of the issue's thematic component explore human rights legislation in Australia. Bruce Chen opens by critiquing the Australian Human Rights Commission's proposed Federal Human Rights Act model, favouring its enactment subject to certain amendments. His piece is highly relevant at the moment, considering the Parliamentary Joint Committee on Human Rights recently tabled a report in favour of introducing an Australian Human Rights Act. One can only hope that the Commonwealth Government will act upon this development, as Australia remains the only Western democracy without a National Human Rights Act or a Constitutional Bill of Rights. In contrasting Chen's examination of the federal level, Tamara Walsh and Dominique Allen conduct an empirical study into the effectiveness of Australia's first Human Rights Act in the Australian Capital Territory, exposing the lack of communal awareness and reliance upon its provisions inside the courtroom. Walsh and Allen's article is followed by a historical study into the evolution of anti-corruption commissions within Australia by Yi Fui Ng and Stephen Gray, who expose that these accountability bodies and their powers are often restricted by the very individuals which seek to hold them accountable. And with the recent resignation of South Australia's Anti-Corruption Commissioner 2 weeks ago due to damaging amendments that have restricted the Commission's ability to investigate corruption, it is clear that their findings are already holding true. Speaking of accountability bodies, Francis Simmons and Chantal Bostock's article explores how the Administrative Appeals Tribunal applied its guidelines on vulnerable persons to refugee applicants between 2015 and 2022, calling for the enhancement of legal representation in complex cases that involve vulnerable persons. Their findings will no doubt be extremely important in the coming months when the AAT is transmogrified into the Administrative Review Tribunal on 14 October. The Thematic's fifth article by Penelope Weller, Tina Poper, Lauren Walsh-Buckley, Joey Cook, and Chris Melia exposed the shortcomings of legal accountability in tort law and mental health care, arguing for the introduction of no-fault insurance schemes and more effective training for clinicians about their duties, powers, and obligations under mental health legislation. Carmel O'Sullivan rounds off by providing an international perspective on the issue's theme. In exploring the Brereton Report's findings, exculpating military commanders from criminal responsibility for war crimes committed by Australian soldiers in Afghanistan, she exposes that adopting its conclusions would have significant implications on Australia's international standing, while also hampering accountability and the protection of individual rights and freedoms during armed conflict. And in light of a whistleblower being the first person to be imprisoned for Australian war crimes in Afghanistan, her article provides a perfect opportunity for us to reflect upon how our country can, moving forward, better hold its soldiers and military commanders criminally responsible for their actions in times of armed conflict. Now, you're probably thinking that I may have perhaps been a tad too ambitious in proposing and publishing a thematic on developments in rights, freedoms, and accountability. And in fairness to you, you'd be right. The areas of rights, freedoms, and accountability are constantly undergoing developments, for better or worse, both in Australia and abroad. Just the other week, for example, a majority of the United States Supreme Court declared that the President of the United States is shielded from criminal prosecution for acts taken in the exercise of their core constitutional powers. The dissenting justices of the court, Justices Sonia Sotomayor, Alina Kagan, and Ketanji Jackson, criticised the majority's opinion for failing to uphold the need for accountability and restraint. In her powerful dissenting opinion, Justice Sotomayor wrote that, quote, "Today's decision makes a mockery of the principle that no one is above the law. In every use of official power, the President is now a king above the law. With fear for our democracy, I dissent." End quote. Despite my ambitiousness with the issue's topic, I can proudly say that the articles housed within its thematic component, and indeed within the issue more generally, clearly live up to the issue 47.2's theme. The articles not only provide topical and creative scholarship on the theme itself, but they also lay the groundwork for broader and greater discourse on rights, freedoms, and accountability as we look to the future. I sincerely thank the issue's 21 authors for entrusting the journal and me with your work, as well as for your warmth and cooperation from the time your articles were submitted all the way through to their publication tonight. It has been an absolute privilege and honour to work alongside you all, and I hope that the journal has done your articles the justice they deserve. Without your ambitiousness in tackling the monstrous task that is the issue's thematic topic, Issue 47.2 could not have come to life. Issue 47.2 could also not come to life without the painstaking efforts of the anonymous peer reviewers in generously offering their valuable time and expertise to not only provide insightful feedback on the submissions that have become the articles of this issue themselves, but to also ensure that what the journal publishes is at the forefront of legal scholarship within Australia. So, to each anonymous peer reviewer, I thank you dearly. It is remarkable to think that as one of Australia's recognised leading law journals, the UNSW Law Journal is only in its 49th year of running. Although it would make more sense to do this in the 50th year of the journal's running, I think that would be a missed opportunity in light of tonight's focus on developments, not to briefly explore the developments of the journal since its birth in 1975. The journal published its inaugural issue in June 1975.
If you steal the content of my speech at this point, I'm going to be very upset.
Comprising 4 articles. Sorry, Perry. First come, first serve. Comprising 4 articles, including one by then Chief Justice of Australia, Sir Garfield Barwick. Should I keep going? Should I keep going? And a forward penned by then Chief Justice Lawrence Street of the New South Wales Supreme Court. Where's that red pen? It's a bit distracting.
It's fine, I'm able, I'll carry it.
It's fine. The journal's publication structure consisted of publishing, over the span of 2 years, a single volume of 4 issues, 2 of which would be published annually. At the time, the idea of a thematic issue was a myth. That was until 1981, when the journal published its first thematic topic, titled Environmental Law, which might sound better than my one, but according to the members of the 1981 editorial board, the principal reason for adopting this format was their belief that publishing a thematic issue would be worthwhile innovation in legal scholarship. The journal's publication structure would undergo several more changes throughout the years until the adoption of its current model of publishing 2 general and 2 part thematic, part general issues. The journal has, however, developed in many more ways than just its publication structure over the last 49 years. But given as we don't have all night, I want to at least mention one. That being the growth of its voluntary student editorial board. While the journal was originally made up of only 4 general board members, it now comprises of 31 brilliant AGLC savvy boardies. I thank them all, many of whom are here tonight, for their countless hours in ensuring that cited cases were to their reported decisions and their diligent efforts in searching the deepest parts of the web to locate seemingly non-existent sources to verify every preposition and citation in this issue's 355 pages and 2,317 footnotes. Tonight is as much a celebration of your hard work and dedication as it is mine. Although the journal prides itself in remaining one of the only student-run law journals in Australia, the continued success of the journal would not be possible without the ongoing support of the university's Faculty of Law and Justice. The journal is very privileged to have Professors Rosalind Dixon and Gary Edmond as our faculty advisors. I thank them both for their learned advice and their cool-headedness, especially when myself and the other members of the executive committee thought the journal was going up in imaginary flames. I would additionally like to thank the faculty's dean, Professor Andrew Lynch, for being the journal's #1 supporter and proponent of our independence. I also express my profound gratitude for his ongoing friendship, guidance and support outside of the journal. The faculty is very lucky to have someone like him supporting the development, pun intended, of its students at its helm. Tonight, of course, would not be possible without the hospitality and breathtaking facilities of Corrs Chambers Westgarth, one of our cherished premier sponsors. I thank Corrs for hosting us tonight, and I extend that thanks to the team responsible for organising tonight's event, particularly Cass, Marianne, and Andrew for delivering that wonderful introduction. I also thank our premier sponsors, Allens, Herbert Smith Freehills, and King & Wood Mallisons for their continued commitment and investment in academic legal scholarship. While there have been many visible propellants of this issue and tonight's launch, there have been just as many hidden ones. I express my sincere thanks to our amazing typesetter Kerry, our cover designer John, the printing team at Laguerre, and issue 47-2's insanely talented artist Jamie, whose artwork can be found on page 354 of this issue. I recommend you all have a look at it. It also means the world to me to have my parents and siblings, as well as my closest friends, here with us tonight. Thank you for listening to all my journal rants, despite having no idea what I was talking about and for your constant love, support, and patience throughout the past year. I'm very privileged to have such an incredible support network, and I couldn't have gotten through my tenure without each of you. I mentioned earlier that the journal has undergone several developments within its 49-year history. But what I failed to mention is that these developments, and indeed the success of the journal, would not at all be possible without the scintillating minds that make up the Executive Committee. To the Executive Committee that I began my tenure with, namely Matilda, Enrico, Hayden, Ella, Anna, Jack, Zong, and Jesse. No words vividly encapsulate the love and admiration I hold for each of you. Thank you for welcoming me with open arms and your ongoing friendship to this day. To the vivacious Executive Committee that I leave tonight, Sharanya, Marcella, Rachel, Jack, Rowan, Fiona, and Cordella. It feels quite poignant standing here saying goodbye. It's been an absolute privilege to complete this journey with you all. Your love, laughter, support, and friendship has made each late night and many hours stressing over short titles worth it. More importantly, I hope that the committee strike system continues on in my legacy as the original strike master. It is now my pleasure to introduce the keynote speaker for tonight's event, Perry Herzfeld. Perry was called to the Victorian Bar in 2009 and New South Wales Bar in 2013, taking up chambers at 11 Wentworth. In what some might call an extraordinary achievement, Perry took silk after only 7 years at the New South Wales Bar and has been recognised as a leading barrister in public and commercial law. In addition to his positions as the current editor of the New South Wales Law Reports and a Fellow of the Australian Academy of Law, Perry is the co-author of the leading text on interpretation, which is regularly cited by superior courts throughout Australia. While at the bar, he has appeared in a plethora of cases touching upon rights, freedoms, and accountability, including in cases of indefinite detention, Indigenous land rights, and notably the suspension and removal of judges in Kiribati. We are also privileged to have had Perry pen the foreword of issue 47.2, which I express my sincere thanks for. Please join me in warmly welcoming Perry.
Brad has mentioned that I have been involved in many leading human rights cases recently decided by the High Court, and that is true. But what Brad tactfully omitted is that almost invariably I have been appearing for the government seeking to squash human rights in Australia.
Protect your reputation.
In fact, a number of years ago, when I went to a dinner put on by the Human Rights Law Centre, one of the other people at my table said to me, "Perry, what are you doing here? You're not a human rights lawyer, you're a human wrongs lawyer." But one of the great things about the bar is that even if you act for the government in one case, you can act for the government in another case, even at the same time. And the reason I was at that dinner where I was accused of being a human wrongs lawyer is that I had done a very large amount of pro bono work giving advice supporting the enactment of same-sex marriage. That may have had some personal benefit for me, given that I married my husband the year afterwards. In any event, I've actually done quite a lot of pro bono human rights work alongside my government human wrongs work. And what I want to speak tonight about is a recent case which Brad mentioned, of a kind that I never thought I would be involved in. It concerns the small Central Pacific island nation of Kiribati. It's a former British colony with a constitution that guarantees an independent judiciary and in some cases appeals to the Privy Council. And like many Pacific Island nations, it has a tradition of having foreign judges serving on its courts. From Australia, they have included Sir Harry Gibbs, the former Chief Justice of our High Court, as well as many eminent New Zealand judges. My client is an Australian lawyer named David Lambourne. He has lived and worked in Kiribati for nearly 30 years. He served as its Solicitor General, and he's married to a Kiribati citizen, and they have children who are also Kiribati citizens. In 2018, he was appointed a judge of the Kiribati High Court, which is the equivalent of our Supreme Court in New South Wales. His instrument of appointment did not specify a term of his appointment. It was to continue indefinitely. For those of you not listening carefully, listen carefully to that. It will be important later in our story. All seemed well until David's wife entered politics and became the opposition leader. In February 2020, David left Kiribati to attend a conference in Canberra, after which he was to take some leave. He planned to return to Kiribati in April, but in March, the government closed the country's borders as a measure intended to combat the COVID-19 pandemic. The Kiribati government then refused to allow David to return to Kiribati and refused to continue paying his salary unless he signed a contract specifying a 3-year term for his appointment as a High Court judge ending in May 2021. Remember when I said it would be important to remember that his appointment didn't have an end term? It's important now because the government wanted to impose an end term for his appointment of May 2021. At the same time, the government introduced legislation into the Kiribati Parliament to impose a requirement that foreign judges be appointed pursuant to a contract. So that was February 2020. Finally, in April 2021, David signed the contract out of practical necessity in order to be allowed back into Kiribati, having been kept away from his wife and children for over a year. And in the meantime, the new legislation passed the Parliament of Kiribati. And the result was that while David was allowed to return, the term of his appointment as a High Court judge would expire in May 2021, and so the government only issued him with a short-term visa until June 2021, after which he would have to leave Kiribati. Once back in Kiribati, David challenged the validity of the new legislation before the only other judge of the High Court, the Chief Justice, formerly a District Court judge of New Zealand. And in December 2021, the Chief Justice upheld David's challenge. The Chief Justice concluded that the legislation was inconsistent with a provision of the Kiribati Constitution. Remember, that's the one that they had, providing that a judge of the High Court, once appointed, held office until the expiry of the term in their instrument of appointment, or until removed in accordance with the provisions of the Kiribati Constitution, which required a finding of misbehaviour by a tribunal appointed by the President, and then removal by a resolution of Parliament. Again, remember those 2 points, they're going to come back later. It's a bit like an exam. Remember these 2 points, they're going to come back later. Since no term had been specified in David's instrument of appointment, his appointment was ongoing. And so the Chief Justice ordered that David be issued with a visa allowing him to return to Kiribati and resume work as a judge. The government didn't accept that ruling. Despite the fact that the Chief Justice refused to stay his orders, the Kiribati government didn't allow David to resume work as a judge or issue him with a work visa. Instead, in June 2022, it established a tribunal to investigate the Chief Justice for misbehaviour, as it was empowered to do under the Constitution, and suspended the Chief Justice from office during the course of the investigation, and the Chief Justice ultimately resigned. Next, in August 2022, the government detained David and tried to deport him, and that meant that there was no functioning Superior Court in Kiribati. It's at that point that I became involved in the case. Fortunately for us, the Kiribati government had appealed the Chief Justice's order to the Court of Appeal. The Court of Appeal consisted of 3 New Zealand judges, one a former judge of the New Zealand Supreme Court, another a former judge of the New Zealand Court of Appeal, and the final one a judge of the New Zealand High Court. While the government attempted to withdraw its appeal, that required the leave of the Court of Appeal. And so the Court of Appeal had jurisdiction, and we therefore filed a cross appeal seeking enforcement by the Court of Appeal of the Chief Justice's orders. We had to do that because, as I've said, there was no other judge in Kiribati to whom we could make any application for enforcement orders. In the meantime, we managed to get an urgent injunction restraining the government from deporting David, which the Court of Appeal issued. There was a 3-hour standoff at the airport. The government refused to let a Fiji Airways plane full of passengers depart Kiribati unless the pilot allowed David to be forced onto the plane by the government. The pilot, who we had made sure through the airline was aware of the Court of Appeal order because we happened to have the email address of the CEO of the airline, they refused to take David unless he was a willing passenger, which obviously he was not. So a 3-hour standoff took place with the plane not taking off from the airport. Presumably the passengers on the aeroplane were told that, a bit like Qantas, that there were technical issues preventing the departure of the plane, and they were all handed bottles of sort of lukewarm water. In any event, ultimately the government, they probably weren't actually handed lukewarm water, they were probably just told to sit there. In any event, ultimately the government relented and let the plane take off without David. But it then took David to a motel where it proceeded to detain him. The next day, we obtained an order from the Court of Appeal granting David bail until a final hearing. Now, all these urgent hearings that I've mentioned were, of course, before the Court of Appeal by video. The judges themselves were in New Zealand, and I was in chambers in Sydney. In fact, at one point, a hearing had to take place over a Teams link that I had to establish because the Kiribati court link was mysteriously unavailable. And on another occasion, the person operating the Kiribati court link expelled indeed, various Australian media organisations from the hearing until I, in a slightly hysterical rant, insisted that they be let back in. We went to a final hearing before the Court of Appeal in mid-August 2022. The Kiribati government had briefed a rather colourful New York-based lawyer called Ravi Batra. He had once sued Dick Wolf, the creator of Law and Order, as well as I'm not making this up, as well as NBC, arguing that an episode of Law and Order defamed him by including an unsavoury Indian-American lawyer, Ravi Patel, said to be based on Mr. Batra. He successfully, in an indication of the state of American law, there was an application to summarily dismiss his claim, which failed. In any event, Mr. Batra, during the Court of Appeal hearing, appealed to the bones of Americans who had died during the invasion of Kiribati during World War II. It's unclear who was invading Kiribati during World War II, but that was his main pitch to legal argument. the Court of Appeal, consisting of those New Zealand judges that I mentioned, were not persuaded by his impassioned plea, and in August 2022, the Court of Appeal quashed the government's deportation orders and confirmed the original orders of the Chief Justice. The government then immediately suspended each of the Court of Appeal judges and established tribunals to investigate each of them for misbehaviour. And at the same time, it suspended David and established a tribunal investigating him for misbehaviour. We instituted a challenge to David's suspension and the establishment of a tribunal to investigate him, but at this point, as you will have picked up for those of you still listening, there were no High Court judges available in Kiribati, and also no Court of Appeal judges available in Kiribati to hear our challenge, or indeed any other legal case. The legal system in Kiribati had essentially ground to a halt. That situation persisted for some time until the government appointed an acting Chief Justice. They appointed the Attorney General as the acting Chief Justice. But of course, she could not hear our challenge because she was one of the defendants. So eventually, our challenge came on for hearing before the only other judicial officer of a superior court in Kiribati, the Commissioner of the High Court. That's a position a bit like a master or associate judge. And he, rather bizarrely, during the hearing had just had eye surgery, so conducted the whole hearing wearing sunglasses. In April this year, apart from ordering that David was owed back salary and directing the government to continue paying David's back salary, he dismissed our challenge. And the tribunal, apparently it was a very boring speech. I thought I was doing quite a lot to entertain you. There was a whole series of meta-humour going on, and nonetheless there was a mobile phone. Anyway, the tribunal, unsurprisingly, found misbehaviour. Its reasons were pretty extraordinary. A key aspect of its reasons were that in a politically contentious case in which David had found for the government, David gave only oral reasons and didn't give written reasons for 7 months while he was being kept out of the country. One part of the tribunal's reasons on this aspect of its findings states, and I quote, "Insert Lambourne's comment on this," close quote. In any case, the tribunal having found misbehaviour, the Parliament unsurprisingly resolved to remove David from office as a judge of the High Court. The Commissioner had refused to give us an interlocutory injunction restraining the Speaker from placing the removal motion before Parliament pending the determination of our appeal of the Commissioner's decision. And of course our appeal from the Commissioner's decision can't be heard at the moment because those of you who are listening will have picked up that there are no Court of Appeal judges in Kiribati at the moment, the appointment of whom depends on the government. The previous Court of Appeal judges, who you will remember were suspended, all had limited term appointments, unlike David, all of which have now expired. So as a result of all of that, David has had to leave Kiribati, leaving his wife, the opposition leader, and children behind. And needless to say, despite the Chief Justice's order, the government has refused to pay any of his back salary. The Commissioner stayed his order requiring that the government pay the back salary pending an appeal by the government, provided that the government pay the relevant amount into court. But since the Commissioner has not specified what amount needs to be paid into court, no amount has been paid into court, and the government's appeal to the Court of Appeal remains like ours in limbo because there are no Court of Appeal judges. All of that has taken place despite the fact that there are very lofty sounding provisions in the Kiribati Constitution Section 3A guarantees to every person in Kiribati the protection of the law. Section 5 sets out a right to personal liberty. Section 10, subsection A, provides that any court in Kiribati must be, quote, independent and impartial. Insert editor's note of Herzfeld vomiting into a cup. And must give every case, quote, a fair hearing within a reasonable time. Insert editor's note, the cup overflowed. The procedures of Section 83 are, as the Chief Justice had found, clear that a judge of the High Court can be removed from office only for misbehaviour found by a tribunal and after resolution by Parliament. Fine-sounding provisions such as these are, however, capable of manipulation and circumvention. A deliberately difficult process for the removal of judges provides no real protection if the members of the tribunal appointed by the government are themselves not independent and do not conduct themselves in a rigorous and competent way. Constitutional references to an independent judiciary and fair hearings within a reasonable time are of no utility if the government simply appoints no judges. Now, these rather depressing events starkly highlight the importance not only of the theoretical existence of rights and freedoms, but also effective methods of accountability. See how I did that with the topic of the... Thank you. Accountability for government and others when rights and freedoms are allegedly infringed. It's very easy to forget in a country like Australia that in many places in the world, discussions of rights, freedoms and accountability concern basic things that we take for granted, like the rule of law. The experience in Kiribati that I have had that I didn't think I would ever have in my career demonstrates that the rule of law is fragile. It depends on more than constitutional structures. It requires a collective willingness to articulate in laws what we can and cannot do, and to submit our disputes to an open, reasoned and independent process by the judiciary. And it requires a government able to resist the temptation of undermining the judicial process when it produces outcomes not to the government's liking. And that requires a strong and pervasive social view that for the government to do such a thing would be such a circumvention of a basic rule of society that it just isn't done. The strength of the commitment of our society to the rule of law is seen in the events from the year the first issue that the University of New South Wales Law Journal was published. Don't laugh, Brad, this is a beautiful segue. That was in June 1975. The foreword was written by Sir Lawrence Street, then Chief Justice of New South Wales. It contained articles by, among others, Sir Garfield Barwick, then the Chief Justice of the High Court of Australia. Brad's already told you that.
Great minds, great minds.
Yeah, but I've got the better bits. So it also contained an article, and this is the part that Brad didn't get to because he didn't go past page 10. It also contained an article by the Honourable Kep Enderby QC, then the Commonwealth Attorney General in the Whitlam government. Only a few months later, Enderby, along with the rest of the Whitlam government, was dismissed by the Governor-General. The role of Chief Justice Barwick in advising the Governor-General during those events has been the subject of subsequent debate. Kep Enderby had also given controversial advice to the Governor-General. He presented to the Governor-General an advice prepared by the Solicitor-General, Sir Maurice Byers, which said that the Governor-General had power to dismiss the government. But before presenting the advice, Enderby, crossed out by a signature, wrote draft on the advice and said that he had not carefully read it and didn't necessarily agree with the views in it. In any event, notwithstanding the vigorous contest at the time, both political and to some degree legal, about the dismissal of the Whitlam government, there was no collapse of the rule of law in Australia. An election took place soon after, as had been required by the Governor-General when he commissioned Malcolm Fraser as the caretaker Prime Minister, and all sides accepted the outcome of that election. In 1981, the Journal published its first thematic issue. Again, Brad noticed this, but didn't actually read it, as far as I can tell. The foreword to that issue said that the editorial board believed, and here's a quote which shows that I did read it, that a thematic issue would constitute a worthwhile innovation in legal scholarship, and that the board was keenly aware of the marked similarities among law journals produced in Australia, particularly in universities, and felt that it was necessary to produce a journal which differed from those presently available. The fact that since that time the journal has continued to produce at least one thematic or part thematic issue each year is testament to the far-sightedness of that board's decision. The themes which have been covered vary considerably, but have always been topical. The first, as Brad has said, was environmental law, coinciding with the recent introduction of the New South Wales Land and Environment Court. Later thematic issues, some of which still sound topical, some of which sound a bit less like topical matters and more a bit like things that our parents discuss. I'm including our in that to, bond with the young people in the audience. They included law and medicine, not sure if that was ever topical, but anyway, law and medicine, intellectual property, current since about 1925. Anyway, family law, the media and the law, the judiciary, white collar and corporate crime, corporate regulation, competition policy, Indigenous peoples, e-commerce, the internet, refugees, the centenary of the Australian Constitution, terrorism, military law, industrial relations, international trade, federalism, personal property, securities, and many others. The analysis of rights, freedoms and accountability in Australia in the articles in this issue cover a range of topical areas. At this point in my speech, I had intended to survey the articles in the issue, but Brad really stole the content of my speech from that, but that is mainly because he copied my foreword, and it is really an indication for those keen to go to the bar of the need for communication between senior counsel and junior counsel. So I will skip my survey of the content of the journal and simply say this. This issue of the journal can take its place proudly with its predecessors. It is right that it covers, as a single topic, rights and freedoms and accountability, because, as is shown by the events in Kiribati, rights, freedoms and accountability are things which can only exist together. Thank you.
Thank you very much. So I am Andrew Lynch and I'm the Dean of the Faculty of Law and Justice, and it's my great pleasure tonight to deliver the vote of thanks. There's already been quite a bit of thanking going on, and I'm going to also repeat some of those, but now at the end of the proceedings, sort of with a bit more information to hand. Certainly that's the case for the first person I wish to thank, which is Perry, for launching the journal in such splendid fashion with his remarks tonight. And one of the things I love about coming to a journal launch is you never really know what you're going to hear about. You know you'll leave smarter about a topic, Kiribati constitutional law wasn't something I was anticipating tonight, but it has been a marvellous survey delivered with in an incredibly engaging and entertaining manner. And I think once you mentioned the sunglasses being worn on the Zoom call, I just thought film rights. I mean, it really has, the story has it all. And of course it ties in so well with the themes of this issue and the importance of institutions and the norms that are supported by the political class as well as the legal profession and the community at large. But the thing that I also took from your story, which you were too modest to mention, was really the doggedness of individual legal practitioners. And you took us very forensically through that story, which was important. There's no short way to tell that story. You need to do it in exactly the way that you did. But it's the hard, detailed work that goes into rights protection that I really took from what you said. And so thank you for sharing that with us. I also want to thank the sponsors of the journal, the 4 major sponsors, but of course tonight our hosts, Corrs Chambers Westgarth. It's always a pleasure to come to these magnificent offices, and the generosity with which we are welcomed is something I always look forward to when I'm travelling in from the university's campus. And I really want to thank Andrew for his remarks tonight, Michelle, Cassandra and Marianne, and other members of the Corrs staff for extending such a friendly hand to us tonight and making us all feel very welcome. I also wish to acknowledge my colleagues, the academic advisors, the indefatigable Ros Dixon, who is tucked away at the back there, and with Gary Edmund provides so much support to the journal and has done so for over many years. And I'd also like to acknowledge my professorial colleagues who are also drawn to the back row. There's a group of them over there who are here in many capacities, I think. They are sometime contributing authors in the history of the journal. Doubtless they've also been the anonymous peer reviewers on occasion as well. But certainly they share, there's some more over there I've just seen. They share with me and the other members of the faculty our immense pride in our student body for producing a completely independent student-run journal of truly worldwide reputation and great quality. I'm really delighted that they would join tonight. My only request is that at the drinks following the official proceedings, they would love to talk to more of you. So they did say that they were gathered in a conclave and said, we don't want to make the students feel uncomfortable. Bail them up, talk to them, particularly if you have any assessment due this term. Now to the journal team itself. I have never heard this expression, boardies. It's quite peculiar, but I gather that it refers to everybody who is working on the journal at any time, and that is a large group of people, many of whom are here. Everybody in the journal team has doubtless contributed in some way to bringing this publication to hands tonight, and you should all feel very proud of that. It's a huge achievement, and the team is so essential. I mean, one of the things I really love about the journal is that no one person can produce it. It definitely depends on different people at different times, but everybody's contribution makes the end product. I obviously want to single out, though, 2 individuals. The executive editor, Shariana, thank you so much for your stewardship of volume 47. It's the long marathon job of the journal. We're only up to issue 2, there's more to come. And that's a demanding job, and it's a pleasure to be seeing how it's unfolding this year with you. And lastly, Brad, who is the issue editor for 47.2. So I've known Brad for a while, and he has done other work for myself and other colleagues, and I noticed that the journal posted on Instagram a profile, I think, to build anticipation for tonight. There's a profile on Brad, and he listed his pet peeves as an editor. One of them, I must say, I've forgotten, but the one that he did mention was that when authors use a source for which there is no template in the Australian Guide to Legal Citation as to how that reference is to be written. And I have quite enjoyed, since reading that this morning, thinking about Brad's inner turmoil in one of those cases, and thinking that it may well have been shared. There would be long meetings in the editorial room to crack this particular unforeseen circumstance. I look forward to reading the journal to identify the author who created that problem authors on this particular occasion. I also didn't expect necessarily tonight to be treated to such a detailed history of the journal, and I learnt things both from the issue editor and the guest speaker. I mean, their remarks were indistinguishable on this front.
So unfair.
It's much more detailed, Perry. Thank you. That I didn't otherwise know, and which was wonderful. I mean, we're really in the land of aficionados now, and. The journal does have a long and significant history. Its identity is very much bound up with that of the faculties. And since Brad did actually thank, he was probably even more comprehensive than I am being, he thanked those responsible for the artwork of the journal cover. And there was reference earlier to me being a champion of the journal. And I sort of thought, I don't know that I really am. I kind of come along and say these things. But I did think about the cover because, of course, it's not yellow in any way. It has none of the telltale signs of being hit up by marketing at UNSW. And that's not to say there haven't been an attempt now and then. So certainly this very serious and, I think quite austere, but in an appealing way, and long may it continue, is something that I feel I have contributed in a small way to the journal's success. So here's to me too. Thank you everybody for attending, particularly family and friends who don't really live much in the world of law journals. Your forbearance has been appreciated, and it'll be really great now to catch up over some drinks and enjoy the hospitality of our wonderful host, Corrs. Thank you.
Thank you very much, Professor Lynch, for that wonderful vote of thanks, and thank you, Mr. Herzfeld, for a very colourful but insightful keynote address.
Don't know how I feel about that.
With Volume 47, Issue 2 of the University of New South Wales Law Journal officially launched, we have now reached the conclusion of tonight's proceedings. Please feel free to remain and mingle for the next 20 minutes or so, and please do not forget to collect your complimentary copy of Issue 47-2 if you haven't already. All of the articles in this issue can be found in the University of New South Wales Law Journal website from tomorrow. Thank you all for your attendance, and I hope you enjoy your evening.